Bills of Exchange Act. Introduction. In this video, we will be reading through the Bills of Exchange Act. The primary goal of this exercise is to force myself to read through the entire text. However, if you are studying this material for any reason, perhaps this video can serve as a helpful resource. You can listen to the content in the background while going about your day. This is the Canadian version of the Bills of Exchange Act. There are other versions as well. The United Kingdom has its own act, dating back to the 1800s. In the United States, similar rules are found within Articles 3 and 4 of the Uniform Commercial Code, UCC. The Canadian and UK Acts provide a consolidated view of rules and regulations regarding bills of exchange, checks, and promissory notes, while the UCC is divided into multiple articles. This Act offers a comprehensive overview and applies universally to most countries. Additionally, the United Nations has a Bills of Exchange Act or Convention, which I may cover in another video. Today, we will focus on the Bills of Exchange Act, 1985, Canada. Reading format. I will be reading the major text sections while skipping citations like revised statutes or minor references. The primary focus will be on the main body of the Act. Bills of Exchange Act, 1985. Short title. This Act may be cited as the Bills of Exchange Act. Interpretation and definitions. 1. Acceptance. An acceptance completed by delivery or notification. 2. Action. Includes counterclaims and set-offs. 3. Bank. Refers to a bank or authorized foreign bank as defined in Section 2 of the Bank Act. 4. Bearer. A person in possession of a bill or note that is payable to the bearer. 5. Bill. Refers to a bill of exchange. 6. Defense. Includes counterclaims. 7. Delivery. The transfer of possession, actual or constructive, from one person to another. 8. Endorsement. An endorsement completed by delivery. 9. Holder. The payee or endorsee of a bill or note who is in possession of it, or the bearer thereof. 10. Issue. The first delivery of a bill or note, complete in form, to a person who takes it as a holder. 11. Non-business days. Days declared as legal holidays or non-juridical days. Any other day is a business day. 12. Note. A promissory note. 13. Value. Refers to valuable consideration. General principles. 1. Good faith. A thing is deemed to be done in good faith when it is done honestly, whether negligently or not. 2. Signature. Where an instrument or writing requires a signature, it need not be signed by the individual personally. It is sufficient if someone signs under the authority of the person. 3. Corporate signing. A corporate seal suffices as a signature for instruments or writings required by this Act. Bills or notes of a corporation do not require a seal to be valid. 4. Computation of time. For acts required within a time frame of fewer than 3 days, non-business days are excluded. Saturdays are considered non-business days for bills or notes but may apply to checks if the drawee bank is open. Checks. 1. Presentment and payment on Saturdays. Checks can be presented or paid on Saturdays if the drawee bank is open for business. Non-acceptance or non-payment on Saturdays grants the same rights as on any business day. 2. Banks not open for business. When a bank branch is not open on a business day, acts requiring attention at the branch are deferred to the next business day the branch is open. Additional clauses. 1. Cross-checks. Provisions relating to cross-checks also apply to dividend warrants. 2. Common Law of England. Unless inconsistent with this Act, the rules of the Common Law of England, including the law merchant, apply to bills, notes, and checks. 3. Protests as evidence. A protest of a bill or note, properly documented by a notary or justice of the peace, serves as evidence of presentation, dishonor, and notice of dishonor. 4. Forgery. A forged or unauthorized signature is wholly inoperative unless the party being charged is precluded from setting up the forgery or lack of authority. Important notes on negotiation. 1. Negotiation by transfer. A bill is negotiated when transferred to another person in such a way that the transferee becomes the holder. 2. Endorsement. An endorsement must be written on the bill and signed by the endorser. A partial endorsement does not constitute negotiation. 3. Bearer instruments. Bills payable to the bearer are negotiable by delivery. 4. Defective titles. A bill obtained through fraud, duress, or unlawful means is defective. However, a holder in due course holds the bill free from defects. 5. Unconditional orders. Bills must contain unconditional orders to pay. Instruments payable upon contingencies are invalid as bills of exchange. Summary. This Act provides a comprehensive framework for the operation of bills of exchange, promissory notes, and checks under Canadian law. It balances commercial principles, negotiability, and holder rights, ensuring a standardized approach while accommodating international practices. Conclusion. For additional clarity or in-depth analysis, refer to Part 2 of this review. Thank you for watching and engaging with this breakdown of the Bills of Exchange Act, 1985.